thing about general eligibility, it's relevant for every title, whether you're working with a youth, an adult, or a dislocated worker. You're going to have to meet the criteria that falls under general WIOA eligibility. So that's the reason why it's really important for this presentation.
I don't know what you did to this volume.
Hello. Somebody's unmuted. I heard somebody having volume problems there. So let's go ahead and get back to the presentation. Also, this is being recorded. So after the recording gets available, I'll send that out, and it'll also be posted on Illinois WorkNet. So it'll be available at any time after it's posted also. Now, the legislation itself came out way back now in July of 2014, and then it became effective July 1st, 2015. For this presentation, there are a lot of commerce policies that's relevant for it. You have general eligibility, you have selective service, adult eligibility, dislocated worker, general youth, which includes out of school, in school, low income policy, as well as the low income levels, which is the Notice 19.03 that just came out newer in May. Have a service priorities policy. The new basic skills deficiency policy is relevant for the WIOA eligibility. Veterans priority of service, something that we'll definitely be speaking about today. Now, also the most recent federal guidance for eligibility is the Training and Employment Guidance Letters, the TEGL 1916, which provides guidance for the dislocated worker in the adult program, and it came out in March of 17. And the TEGL 2116 was the youth guidance that also came out in March of 2017. So that is the most current guidance that has came out from Department of Labor. Typically, it seems they'll come out every 3 or 4 years or so with updated guidance. But this is the most recent from them. Before we get into the eligibility portion of general eligibility, I do want to touch on Training and Guidance Letter 3912, which is dealing with personally identifiable information, so PII. Some of the things about PII, it's not only in federal guidance, there's Illinois state law. It includes the Identity Protection Act, the Personal Information Protection Act, the Illinois Data Security on State Computers Act, and then that WIOA final rule touches on PII also. There's federal uniform guidance that just speaks about taking responsible measures to safeguard protected personally identifiable information and other information that the awarding agency or non-federal entity designates as sensitive. So when you think about this, you know, your client is trusting you a lot, so they're given a lot of personal information about themselves and about their family members. And then we take that information and we put it into electronic databases, electronic systems with our IWDS system. So there's a lot of security guidelines that we need to make sure we're following. There's also the employer pass-through entity policies and procedures that's reflected due to protection of PII. And so let's go on to the definition of PII. So Department of Labor defined it as information that can be used to distinguish or trace an individual's identity, either alone or when combined with other personal or identifying information that is linked or linkable to a specific individual. And there's a similar definition in the uniform guidance of the rules within the WIOA legislation. So protected PII information that, if disclosed, could result in harm to an individual, according to the uniform guidance. And this does not include the PII that is required by state law to be disclosed. And then you have non-sensitive PII information that, if disclosed by itself, could not reasonably be expected to result in harm. But a lot of people that are unscrupulous out there is they look to match up the non-sensitive PII with the protected PII, and that's how you find a lot of folks will do identity thefts and things like that by doing some digging through people's computers and their garbage and things like that. So again, we want to safeguard our client and our client's family information from those folks who are looking to do bad things with their client's information. So PII and other sensitive information must be protected. We don't want to email sensitive PII unless it's encrypted. Don't store sensitive PII on portable drives or media unless it's encrypted. Don't access or store PII data on personally owned equipment at off-site locations. Access to any PII created by a ETA, a grantee, must be restricted to only those employees who need it in their official capacity to perform duties in connection with the scope of work in their grant agreement. You know, it's not only in IWDS. You know, if you think about, we have a lot of access with other computer systems, maybe the IBIZ system, where we'll go in to Illinois Department of Employment Security and look up employee wage information. So in this last bullet, you know, if you have the ability to go into clients' information, you should only be going in there for work related. It's nothing that we should ever go into any of the systems to look up information on coworkers or family members or friends. It's only used for our own work. So bottom line, you must keep all clients' personal information protected from unauthorized personnel. Now let's move into the general WIOA eligibility requirements. One of the things is we have the WIOA General Eligibility Policy, and it's Chapter 5, Section 1.1, and it covers some basic information, and one is all of our clients must be authorized to work in the United States before they can meet general WIOA eligibility. And the next general eligibility criteria is if a guy is turned 18 and he was born on or after January 1st, 1960, they must be compliant with selective service before they would meet general eligibility criteria. Now, when you look at the general eligibility policy, that Chapter 5, Section 1, it also gives different guidance about there must be a signature on the application to make it official. And there's a lot of other good guidance. So if you haven't ever taken time to review that Chapter 5, Section 1, the general eligibility requirements, I highly recommend you do that. So let's talk a little more about authorized to work. Participation in the WIOA programs and activities is limited to United States citizens, lawfully admitted permanent residents, aliens, lawfully admitted refugees and parolees, and other persons authorized by the Attorney General to work in the United States. Some of the things you got to consider, it needs to be an unencumbered ability to work in the United States. Sometimes maybe you'll find somebody who has an INS card or immigration authority to work in the United States, but maybe it's limited. Came across an issue a few years ago, and it was a guy, and he was from Canada, and he was authorized to work in the United States at one company. And he lost his job at that one company that he was authorized to work in the United States. He was eligible for unemployment benefits. So if you look at a dislocated worker, he was on his way to eligibility, but his authorization to work in the United States, the only possible job he could ever get would be back at that company that let him go. So if we bring a guy in and start serving him under our WIOA program, finish his services, he exits, he doesn't have an ability to work unless he gets a job back at that same company that let him go. So he doesn't have an unencumbered ability to work in the United States, so you have to be looking at that. Somebody's on a student visa, you've got to be looking at the restrictions, when that student visa expiring. If it's expiring in the near future, and you ask what's going on to get that renewed, and there's nothing going on with it, that's something you got to take in consideration and look to see where they're at. So those are some of the things to think about relevant to authorized to work in the United States. Most of your clients are going to be authorized and have the appropriate documentation. So I just threw out a couple of those examples of some things we've came across in the recent past. The questions related to authorized to work in the United States is captured on the private information screen within IWDS. How that works in IWDS, the only response that'll be allowed on that private information screen is yes. If you have any other answer, well, there's only other one is no that you could put there. When the application is certify or attempt to certify, determine eligibility, if that has a no response, the client won't be eligible for any WIOA title. one of the things that comes about is somebody contacts me and they say, hey, Jim, I created this application, I determined eligibility, and the client is not showing eligible for anything. I'll go to this screen often just to see if by accident maybe they'd populated authorized to work in the United States with a no, because sometimes that does occur on accident too. So the next general eligibility topic I want to touch on is selective service. Now, selective service, you have the policy 5.1.1, and the majority of males who are 18 years of age or older who were born on or after January 1st, 1960, will have already registered with selective service more than likely. However, there are instances where sometimes an individual might not have registered with selective service. And one of the things, if they're under the age of 26 and they come in, you can just have the client register then, because they do have an ability to register once they turn 18 all the way up to the age of 25. They're supposed to do it when they turn 18, but sometimes things happen or maybe they didn't know or whatever it is. But as long as they haven't turned 26, they can still register and move right into their eligibility. But if they haven't registered and they're over age 26, the only possible way that you could serve that guy who's now over age 26 and who's not compliant with selective service is they'd have to have one of those locally approved selective service waivers. And we'll speak more about that in a moment. So if a client is a female or a male born prior to January 1st, 1960, the selective service compliant question in IWDS would be not applicable. If a client was born a male under the age of 18, selective service registration at application time would be not applicable also. So again, if a guy was born prior to January 1st, 1960, or if it's a female, or if a male who's under age 18, in the IWDS record, it should be not applicable for the choice. Now, if a guy was born on or after January 1st, 1960, the only acceptable answers that'll bypass logic in IWDS will either be yes or locally approved waiver. If you have any other answers, if there's a no or not applicable, well, if you put a no, the internal logic of IWDS will take that, but what will happen is the client won't be eligible for any WIOA title. And if you put not applicable, if you try to leave the screen, there'll be an error message that'll say that's not an acceptable answer for any guy that's born on or after January 1st, 1960. Now, most individuals born a male who have turned age 18 will have been compliant with selective service. However, most probably will not know their selective service number. To obtain their selective service number, on the private information screen in IWDS, there's a link, Verify Compliance. That screen's been updated in the recent past. Here's an example of how it looks now. So when you bring it up, there's two choices. You can have the client, if he's 18 and under the age of 26, he could actually just register if he has not registered yet. But if we're looking to verify, like the guy said, yeah, I've already registered with selective service, if you just go and verify registration, what will happen, it'll send you down to a screen, and it's just asking for the client's last name, his social security number, and the date of birth. And then you got to prove that you're not a robot. And then it does the search, and it'll give that selective service number. I used my own information just so I could get a real life example. So in this case, it's got my date of birth, it's got the date I registered, and it's got my selective service number. In real life, if you were my career planner out there, you'd want to print out this, and it would go in my hard copy or in the hard copy file to support my selective service. We'd take our selective service number, and you'd push that over and populate it into the application of IWDS to show the selective service compliance. Now, the real issue that's going to come into play with selective service, because as I mentioned, most guys will have registered with selective service, but when they haven't, and we're trying to still serve it. So we got a guy, he's born on or after January 1st, 1960. He's now 26 or older, and he didn't register with selective service. and we need to do a waiver. Some of the reasons that are most often for waivers, it seems to be for folks who entered, a guy might have entered the country for the first time after he had turned 26. Other folks, you come across some guys who might have went in the military when they were young, 18, and they didn't register because they thought, hey, I'm in the military, why do I need to register with Selective Service? And some other folks, it seems, that come up often for the locally approved waiver, or maybe somebody that was incarcerated from a young age and did not register. Some of the details about, we'll cover the military for one. If somebody does serve in the military, when they get out, they're supposed to register with Selective Service within 30 days of getting out. But let's say somebody like myself, I enlisted in the Air Force when I was 18, and I retired when I was 38. So if I would not have registered, it would have been very common for me to have just said, hey, I didn't need to do that because I was in the military that whole time. So again, they do still have to have a waiver. If you're over the age of 26 and you're not compliant with Selective Service and you were born on or after January 1st, 1960, there must be a waiver in order for the client to receive WIOA services. So again, the first step for this, any guy that's born a male, who's born on or after January 1st, 1960, the first step for a waiver is within our Selective Service policy, there's a SS or DCEO SS Form 1, Selective Service Form 1. And what that is, it's basically just a one-page document, and it allows the individual to give some background on why he did not register with Selective Service. And one of the things about a waiver, the client must show that he did not willingly and knowingly fail to register. Meaning if the client says, yeah, I knew I was supposed to register with Selective Service, but I just chose not to, he cannot receive a waiver. The approval authority is not able to approve that waiver. So again, the client has to prove that he did not willingly and knowingly fail to register. So the next step after the client fills out that DCO SS Form 001 is they must get what's called a status letter. Now, a status letter, it comes from Selective Service, and it's kind of funny because basically the status letter states that they're too old to register, and and here's a letter to support that. A couple of things that's really important to understand about the status letter. For a locally approved waiver, there are two groups of people that do not need status letters, and that are folks who came in the country for the first time after the 26th birthday are not required to obtain a status letter for a waiver, and also an individual who is a veteran is not required to obtain a status letter. All the other individuals who need a waiver must receive that status letter as part of the waiver approval process. So again, to reiterate, if we're doing a waiver, the first step is the Selective Service verification, the DCO SS Form 001 the client fills out. The next is getting a status letter from Selective Service, but that is not needed for a client who came into the country for the first time after his 26th birthday and has documentation to support that, or if the client is a veteran. And the next portion for who approves the waivers. Part of the Selective Service guidance within the policy Chapter 5, Section 1.3, it establishes that each local area, each LWIA, must include who their approval authority is within their own local policy of Selective Service. So to understand it is a local area must declare who is going to be the approval authority. Most times it seems to be like a director or assistant director, but again, it's each local area's determination. Commerce doesn't determine that. But whatever is in the local policy, when a monitor is going to come out, both either a state monitor or a federal monitor, they're going to ask to see a local policy and then if somebody has a waiver, to see if you followed that policy itself. But your local policy cannot override the state guidance, which states that you must have each client start their waiver with that DCO form SS Form 001. So So again, in real life training, and when I go out to visit you folks out in the field, I provide these hard copies of the different policies, and I always give an extra couple of those DCO Form 1s. And I highly recommend as a career planner staff that you make yourself some extra copies and just keep them handy. And anytime a client, if he's over age 26 and he's not compliant with Selective Service, the first step you should do is hand him one of those DCO SS Form 001 to get the waiver process started. So then whomever is the approval authority at your LWIA is going to look at the information. They have to look at the circumstances or why the man did not register with the Selective Service. The next they're going to see if there is a status letter, did we get that status letter if there's a requirement for it. And then they're going to weigh all the information. And if the waiver is approved, then the IWDS record would be populated with locally approved Selective Service waiver. And here's an example of the slide here. Now for this mock client, the expectation would be in his hard copy file is that complete waiver. So never ever put locally approved Selective Service waiver unless you truly have that, because it could be a case of disallowed costs if we went and put locally approved waiver for a guy who you hadn't followed the entire steps to get that waiver. Now, if the locally approved Selective Service waiver is approved, that all documentation approving the waiver must be placed in that client's record, as we just spoke about. One of the things, as I touched a little bit, if the failure is deemed to be knowing and willful, then he must be denied WIOA services. So if he said, yeah, I knew I was supposed to register, I didn't, he must be denied. Decisions are made on a case-by-case basis, meaning there should never be a carte blanche approval process saying, hey, yeah, everybody that needs a waiver gets one. They have to be looked at on an individual basis. So here's something else we have to consider. Often we have guys that come into our youth program and they're under the age of 18. So they're not required to be compliant with Selective Service at time of application. However, to continue to receive WIOA services when he turns 18, he must register with Selective Service no later than 30 days after turning age 18. So, and actually, just a little bit of insight, when a male who entered the program under the age of 18 gets within 30 days of his 18th birthday, he can register with Selective Service. So what happens for internal logic within IWDS, when a male is within 30 days of turning 18, the private information screen related to Selective Service on the application opens up to allow it to be updated. Next slide is an example. So here's a mock client, Harpo Marks. He came in the program when he was under the age of 18, and now he's getting ready to turn 18. So we go to the private information screen, and he's within 30 days of turning 18. He just happened to do it today. So at application, it was not applicable. So now Harpo Marks has went and registered with Selective Service, so that response could be changed to a yes. And then we'd have his Selective Service number if he's registered. We'd put that in, and then when you just hit save, it just locks it back up, so the record's sealed. And again, this is at the application level. We have a lot of times people update at the customer level for the Selective Service information, and they're still getting issues when they run those reports of registrants who are not compliant with Selective Service. So you have to update it at the application level for the Selective Service. So again, when a client gets within 30 days of turning 18, his private information screen opens up to allow it to be updated at his application level. Once it's been updated, then you would just put the information in, save it, and it relocks as demonstrated here. Couple of issues that I do want to pass on related to Selective Service and folks under 18. It's worth asking the clients or making sure that a client who is under 18 understands that when he turns 18, he is required to register with Selective Service. You should find out if he's going to have an issue with that, hopefully before you put him in services. sometimes maybe you'll tell him that you'll ask that question. He might state he doesn't have a problem, and then he turns 18, and maybe he'd gotten some other information from some outside sources, and all of a sudden he decides he doesn't want to register. If that comes about, if a client is turned 18 and he states, no, I'm not going to register for Selective Service, what do we do? Well, in that case, we close out all services. If he fails or refuses to register Selective Service, you must close out all WIOA services. If you provide if you continue to give him services, those could be disallowed costs because you're serving a client who is no longer compliant with WIOA requirements, meaning he did not register with Selective Service. You wouldn't have to exit him right away because you can go 90 days without a service before you have to be exited. What I would recommend also is to explain to him, by choosing not to register Selective Service, you're going against federal law, which there is repercussions. If you look at the Selective Service website, I don't know if they've ever prosecuted anybody, but it talks about jail time and $10,000 fine for somebody that's not compliant with Selective Service. I do know there are restrictions for financial aid. You're not going to get Pell Grants and student loans if you choose not to follow the federal guidance on Selective Service. Department of or any federal job programs for hiring a client who's not compliant with Selective Service is not able to get into those programs. Any other programs such as WIA or WIOA that are federally funded that have compliance with Selective Service as part of their eligibility, the client would not be able to participate in. So one of the clients, we had an issue been a few years ago, and the guy stuck to it, and he said, no, I'm not registering. And he had obtained his GED while he was in services, and he was concerned that his GED was going to get taken away. So nothing like that could happen. He couldn't change anything that's already happened with the guy's services, but he could not continue to get services. Also, something about the failure to refuse or failure/refuse to register. A client has up to 30 days after his 18th birthday to register with Selective Service. But if on his 18th birthday he tells you, no, I'm not registering, his clock for 30 days stops because he's told you he is not going to register. So at that time, you close out services. So the 30 days is the time frame a person is allowed up to 30 days to register. But as soon as he would state that he's not going to register or it says, hey, I'm not going to do it, we would close his services out. Overall, I don't believe there's probably been that many clients this comes up, but it does periodically. So again, I would highly recommend when you're bringing somebody in under the age of 18, as you pass on that in order to participate in this program, you must be compliant with Selective Service, and look him in the eye and say, are you going to have a problem with that? And see if you can deal with that up front if there might be a possible problem. Again, I touched on it earlier, if a male who entered the WIOA program under the age of 18 and he refuses to register with Selective Service when he turns 18, and if he continued to receive WIOA services, any services provided after that 18th birthday could be disallowed costs. So that's another reason to be on top of our people who are turning 18. There's reports in IWDS of registrants that are not compliant with Selective Service, and that's strictly for this youth program to find those folks who are coming up on their 18th birthday who might have already turned 18. So any of the folks who oversee the youth, or if you're a youth career planner, I highly recommend you be familiar with that report. You run it on a monthly basis to make sure that you're capturing those guys that are turning 18 or have turned 18. Also, for youth clients who exit, you're supposed to be making sure that they're compliant with Selective Service because they're still in WIOA services. Plus, it's just good customer service. When he turns 18, even if he's been exited, we should check in to see if he's compliant with Selective Service and update our records accordingly. If at that time he refuses to register with Selective Service, you would even close out follow-up. We wouldn't continue to provide that follow-up service. But we don't want to use that a reason to close out follow-up service early. because I could see somebody maybe, hey, I left Jim a message saying he needed to register Selective service. I never heard back from him, so I closed follow-up. And that's not the proper way to do it. We want to make sure we're contacting them, telling them, hey, you need to register Selective service. It's federal law, and then help him as much as possible to track that all the way through. So bottom line, any WIOA client who was born a male on or after January 1st, 1960, who has turned age 18, must have a selective status of either yes or a locally approved waiver. Those locally approved selective service waivers are only for clients who are born a male on or after 1/1/1960 who have turned age 26 and can no longer register with selective service. Next we're going to touch on is veterans' priority of service. It's covered in Commerce's policy, Chapter 5, Section 7, Chapter 5, 7.1, and Chapter 5, 7.2. The guidance is on the various veterans and veterans priority of service issues. It also goes back to the Jobs for Veterans Act, this guidance does. So let's first review the definitions related to veteran, qualified spouse of veteran, and transitioning service member. And this is a poster. It's part of Commerce policy. And what Commerce policy states is this poster is supposed to be posted at a point of entry of any program that's partially or totally funded by Department of Labor. And our program, of course, is. So this should be up and it should be clear, so when folks come in the program, they could see this, and maybe it'll have them ask the question, hey, what's this priority of service for veterans and eligible spouses? So again, that's a little commercial for our policy folks to make sure that this poster is being displayed at a point of entry. And so now let's talk about some of the key definitions. You have a covered person. So a covered person is either the veteran or the eligible spouse of a veteran. So to be considered a veteran for priority of service, it comes across as anyone who served on active military, naval, or air service and has a discharge other than dishonorable. So when I say active service, you just have to have 1 day of active service. But a key to understand about active service, it's after training. I mentioned I went in the Air Force. If I'd have gotten booted out in basic training and didn't make it through, I would have never went on active duty. So you go through basic training, then you go off to your training to do your job. After you get through that training, then you go to your first duty station. Then you're on active duty. So anybody that serves 1 day on active duty, and then as long as their discharge is not dishonorable, they get veterans priority of service. The next one is an eligible spouse of a veteran. Sometimes there's a misunderstanding that just somebody married to somebody who'd been in the military makes them an eligible spouse, and that's not accurate. To be an eligible spouse, it must be the spouse of a veteran that dies of a service-connected disability or died while a total service-connected disability per the Veterans Administration evaluation was in existence, or the spouse of the veteran who is missing in action, captured, or forcibly detained by a foreign power for more than 90 days, or the spouse of the veteran who has a complete total service-connected disability per VA, Veterans Administration. So a spouse of somebody who's 100% service-connected disabled. Those are the criteria to be an eligible spouse. So you'll notice it's pretty limited. So you might not come across very many folks who meet the eligible spouse criteria. But that is the covered person's definitions for veterans priority of service. This would also include, it's not mentioned, but if a person was a transitioning service member, meaning he or she was in the process of getting out or retiring from the military, they would also get veterans priority of service. So what does veterans priority of service mean? If you have an individual is a veteran or a qualified spouse of a veteran or a transitioning service member, they are considered a covered person. However, for WIOA eligibility, the covered person status is not an eligibility factor itself. The individual must still meet eligibility for a particular WIOA program, whether the adult or dislocated worker or youth, to receive veterans priority of service. So as an example, let's say we have two people that come in and they're dislocated worker clients, and one's a veteran and one's not a veteran, but they're both qualified as a dislocated worker. Well, then that veteran would get the priority of the client that's not a veteran because they're both qualified. But if I came in as a veteran and the local area just had money for a dislocated worker, they had expended all their adult funds, and another guy came in and he met qualifications, or a guy or a gal, as a dislocated worker, the person who qualified as a dislocated worker would be a higher priority than myself because I didn't qualify as a dislocated worker. So again, it's important to understand that just being a veteran doesn't make you automatically eligible. It falls a priority if you do meet eligibility. And we're not going to cover it in this presentation, but understanding the adult population, you know, to be an adult, 18 or older, Selective Service compliant, authorized to work in the United States. So most individuals are going to meet the adult title eligibility. Now, there are different priorities under the adult given for folks who are basic skills deficient or low income, but also a veteran's priority of service comes into play for an adult. So an adult who's a veteran would have priority over an adult who's not a veteran that doesn't meet any priorities. But if an adult who is a veteran comes in and he is not basic skills deficient or she is not low income, and another individual comes in who is an adult that's either low income or basic skills deficient, they would get services as an adult prior to that vet who didn't meet either basic skills deficient or low income. So again, understanding veterans priority, it does come into play, but you do have to meet eligibility criteria. So what does a veteran's priority of service mean? If an individual meets criteria, the individual gets front of the line service, first opportunity, and if opportunities are limited due to funding, the WIOA/grantee staff must ensure the covered person receives services for an individual who does not meet veterans priority of service requirements. Within the application of IWDS, it comes about that there's questions of veterans or qualified spouse of veteran or transitioning service member. If a client's either a yes or qualified spouse or transitioning service member, that's the first step. And then later on in the application, it asks if there's documentation to support veteran status. That's one of the keys, that we must have the documentation to support it. So if a guy or a gal comes in and they tell you that they're a veteran or a qualified spouse or a transitioning service member, but he or she does not provide you the documentation to support that, then you should not be recording them as a veteran. You should only be recording them as a veteran if you have that documentation to support it. Now, one of the things, sometimes people have misplaced their documentation, so we don't want to hold up our application. So just record it as no if they haven't provided the application or the documentation. And then at a later date, if they did bring in their DD-214, their record of discharge, you could send up a record from IWDS record modification, and we can make the update to the record, because we definitely want to make sure we record veteran status and everybody who is a veteran or qualified spouse, but again, they must have that documentation to support it. So in conclusion, for all WIOA titles of eligibility, it's important to realize that protection of personally identifiable information is the utmost importance. All individuals must meet authorized to work in the U.S. criteria. It's important to understand those intricacies of selective service criteria for any guy or anybody who's born a male who was born on or after January 1st, 1960 and has turned 18. And then for those youth who came in under the age of 18, who then turned 18, to understand that they must be compliant. And then lastly, we covered the veterans priority of service, and it's required to be followed for every Department of Labor funded program, including and not limited to WIOA. This concludes the presentation on WIOA general eligibility. If you have any questions, feel free to contact me at my email, or you can call me at my cell, which is 217-416-7097. So we're going to go ahead and open it up for questions. If anybody has anything related to general eligibility, authorized to work in the United States, compliance with selective service, veterans priority of service, or any other topics related to what we just covered, feel free to let me know. And while we're looking for questions, I'm going to bring up the low income PowerPoint. Is there any questions out there, David?
So far, we have one in the chat. If a person says they did not know they needed to register, are they eligible for a waiver?
Yeah, if they stick to that question, that's, you know, if they stick with that answer, that would be a justifiable, or it should be. I mean, your local area is going to be the approval authority. So I don't know if each local area is going to interview, because some might interview somebody and check to see if they stick with that story. But if a client states, yeah, I just didn't know I was supposed to register, who are we to tell them, yes, you did know? So yes, that would be a viable answer for it. Now, here's one of the things. If a person was a previous WIOA client, and let's say he did not register Selective service, and then we had one of our career planners do their due diligence, and they put in the case notes that stated, hey, Jim refused to register. Well, that wouldn't work. So if he has never been a WIOA registrant, and he claimed that he never knew, we wouldn't know. But if he had been a previous WIOA registrant, I highly recommend looking through the file. And I recommend that all the time to see what type of customer, but it's a viable excuse the first time. We don't have any other questions tied to general eligibility, because it is fairly straightforward. Probably the biggest question that I could see coming up would be those selective service and the waivers and things like that. So that was a good question. Again, if you have any other questions that come up, feel free to shoot me an email or give me a ring. It doesn't have to be through this formal process of the training today or the webinar. So we're going to move on now is to the WIOA low income presentation. And what low income is really important to understand if you work with the adult title and the youth title. As a matter of fact, it's impossible to be a youth career planner or an adult career planner if you don't understand low income. So the guidance, as I mentioned with general eligibility, the WIOA legislation itself came out back in 2014. It was effective July 1st of 2015. Commerce, you have Commerce Policy Chapter 5, Section 5, which is for low-income individuals. Additional guidance is provided in Training Employment's Guidance Letter 1916 for adult and dislocated worker, and TGOL 2116 for the youth program. Adult program, the priority of service for individuals who are low income. For in-school youth, 95% of clients must meet WIOA low income criteria. And for out-of-school youth, depending on what barriers the youth has, he or she might be required to meet low income. Another thing about out-of-school youth, even though majority of the out-of-school youth requirements criteria do not require you to meet low-income guidelines, if your out-of-school youth client does meet low-income guidelines, I highly encourage you to record it, have that documentation to support it. And the reason why, it's for your regression analysis for the barriers. The more barriers a youth has, the more difficult it is for he or she to successfully get through this program. So you want to get credit for all the barriers that a client's dealing with. So if you have an out-of-school youth who maybe has a disability, and that barrier alone would support his eligibility for the youth program, but if he's also low income, when you're starting to go for your regression analysis to look at the clients you're serving, you should be recording that low income also, because it would show he's a low income youth who has a disability. So again, you want to think about it not just for eligibility, you also want to think about making sure you're getting credit for the whole person. So especially for the out-of-school youth, where the majority are not required to meet low-income guidelines, but a lot of times they still might. So I would encourage you to still record it if a client does meet the out-of-school or does meet low income, but you do need to have the documentation, even though it won't be needed at certification, but for federal monitoring, for state monitoring, if you state an out-of-school youth is on food stamps, even if you didn't need it, there should be documentation to support that. So I want you to record it, but only if you have documentation to support it. in out-of-school youth even if it's not needed. So the state policy, as I mentioned, we have Chapter 5, Section 5, and in that it has two attachments. It has an Attachment A, which is the different documentation choices that can be used to support the different eligibility criteria. One of the things about Attachment A, it's the Attachment A for all of your eligibility policies. So in that last presentation, when I spoke about the general eligibility, which was Chapter 5, Section 1, it had Attachment A of the documentation. The adult policy, it has Attachment A with the documentation. The youth has Attachment A, which is the documentation. The dislocated worker also has the Attachment A of documentation. So again, the Attachment A is the same one for all the eligibility. And Attachment B, it's really important for the low income to understand if you have to do an income calculation. Attachment B is the inclusions and exclusions lists for the income. Sometimes I've came across where folks have actually put in includable income within an income calculation and then determined the person was over income guidelines. So it's really important to know, or excuse me, excluded income. It's really important to know those exclusions and keep those out. And I'll give you an example. If you're near a military installation, or if your client or your client's family member is in active duty military, all payer allowances while on active duty is excluded if an income calculation is completed. So within the states, down in Belleville area, you have Scott Air Force Base, which is a large Air Force base. Up in Great Lakes, WIOA you have Great Lakes Naval Center. So if any client that's family members that's active duty military, it'll be just as if they had no income, if that's their only income of pay and allowance as well on active duty. So again, that's just a little commercial on that exclusions, how it's important to really understand what that exclusions list if you're doing an income calculation. The other policy notice I want to speak about is WIOA Notice 19-03. What that is, it's the income guidelines, thresholds, the amount of income broken out by family size and broken out by the different LWIAs across our state. That was updated in May of 2020. It went up a little bit across most of the categories. When a client is trying to be determined low income, there are 8 different ways that low income could be determined. Those are cash welfare, food stamps, homeless, free or reduced price lunch, foster child, a youth customer living in a high poverty area, a family income calculation, and a family of one due to a disability. There are 6 of those. The first 6 are, I like to call them as automatic qualifiers. Meaning if a client meets any of the criteria in those first 6, you don't have to mess with doing that family income calculation. And then family of one due to disability wouldn't be you wouldn't have to deal with that at all if a client had met one of the automatic qualifiers. So to meet low income criteria, a client would only need to meet one of those 8 different low income criteria. However, if a client claims to meet low income criteria in multiple ways, then the expectation at eligibility determination would be to have verification documentation for each of the criteria claimed. And I'll give you a good example of that. Often, sometimes you'll find a record that said yes to both food stamps and yes to both TANF. Then comes time for certification, they would need documentation for both food stamps and TANF if they'd said yes to both of those questions. When it comes time to monitoring, or in my case, it was data validation, we'd go into the file and maybe there was documentation to support food stamps, but there wasn't anything to support TANF. So the client still met eligibility because they had one of the 2, but they would have failed whichever element in validation because they didn't have what they'd claimed. So again, understanding there's 8 different ways to meet eligibility, but if you've selected yes to more than one, you still must have documentation to support that. So again, those 6 that are automatic but do not require the income calculation: cash welfare, food stamps, homeless, free or reduced price lunch, foster child, youth living in a poverty area. In the policy, how it's worded for cash welfare and food stamps is personally receives or is a member of a family that receives or received in the past 6 months either cash welfare or food stamps. So some of the things that's important to know here is the client themselves receives or they're a member of a family. Well, the family, it's really important to understand, it's got to be the WIOA defined family. It can't be my definition of family or yours. We must follow that WIOA definition of family. Some of the other things to understand about cash welfare. You have the most common forms of cash welfare are temporary assistance for needy families, TANF, SSI, supplemental security income, and then there's other state or local income-based public assistance programs. But again, you'll probably find that TANF is probably the most well-known of the various cash welfares. SSI, supplemental security income, this one gets confused sometimes with SSDI, Social Security Disability. Supplemental security income is typically given to somebody who is younger or older and has a pretty significant disability. So a lot of times the client himself or herself that's on SSI, they might not be an ideal candidate for our Title I. They might be better for our partners with vocational rehab. I'm not saying that 100% of the time. I'm just giving you examples of what I've seen most often. But one of the things to understand is that definition is currently receiving or a member of a family that receives. So if somebody's on SSI, let's say we have a child that's on SSI, everybody in his or her WIOA defined family would still meet low income guidelines based on the use being on SSI. So that means the mom and the dad could be determined eligible as low income based on their child receiving SSI. That definition of family, it's really important everybody understands this. The term family means two or more persons related by blood, marriage, or decree of court who are living in a single residence and are included in one or more of the following categories: married couple and dependent children, parent or guardian and dependent children, a married couple. What people have a tendency to do is they want to read portions of this definition. You'd have to read the entire definition. A lot of times I'll get contact and they'll say, hey, we got these people and they're related by blood, and it's second cousin Johnny living with his cousins and friends and things. No, we've got to look at the whole definition, and the client would have to fall into the entire portion of our definition. So referring to the question about family, Charlie and Betty live together and they are not married. They have a son, Tommy. Betty comes in for WIOA services. How many people are in her WIOA defined family, and who are they? So again, Charlie and Betty live together. They're not married. They do have a son, Tommy. Betty comes in. The family size of 2, Betty and Tommy, based on the WIOA definition of family, to be considered a family of 3 in this situation, Charlie and Betty would need to be married. Now let's say that Charlie came in for services. If Charlie came in for services, he could also claim Tommy, his son, because again, if you look at that family definition, it's parent, guardian, dependent children. So then Charlie, if he came in, he could be a family of 2 also with himself as well as his child. Now on this is an example of the public assistance screen that's in IWDS. The transitional assistance, refugee help, SSI, and TANF. Those are all correlating to cash public assistance within the internal logic of IWDS. Food stamp is, of course, food stamps. On this screen, you'll notice SSDI is on there, Social Security Disability Insurance. This is required question for every client per DOL reporting. So the programmers chose to put it on the public assistance screen, but it is not a form of public assistance that would support low income. So if it's a yes to SSDI, it's not a form of public assistance. In fact, if you're doing an income calculation, the payments received while on SSDI are an includable form of income. So as I mentioned earlier, temporary assistance for needy families, SSI, supplemental security income, state or local income-based public assistance are those cash welfares. Those questions, transitional assistance, refugee help, SSI, TANF will be registered be considered for cash welfare for internal logic of IWDS. So in this case, I've said yes to TANF. One of the other things about a yes to TANF within internal logic of IWDS, it's going to require you to put a DHS case number. So anytime you have a yes to TANF, the internal logic is going to make you put a DHS case number. Also, if you'll notice at the bottom, months received TANF in prior 60 months is an asterisk item, meaning it's required response. So in this case, it would be applicable because the client had received TANF, how many months it received. But even if they had never received TANF, you still have to populate a number in that. So if somebody has never received TANF, it would be a 0, of course. So a question about cash welfare. Betty is currently receiving TANF benefits. She lives with Charlie, but they are not married, and Charlie is not on the household determination of the TANF printout. If Charlie came in for services, could he be determined low income because he lives with Betty and she receives TANF benefits? And that answer is no. Charlie cannot be determined as low income under WIOA due to Betty receiving TANF, as they do not meet the criteria under the family definition since they are not married. The WIOA definition of family, again, I'm going to reiterate that. The family means 2 or more persons related by blood, marriage, decree, or court who are living in a single residence and are included in 1 or more of the following categories: married couple, dependent children, parent, guardian, dependent children, married couple. So back what I'd touched on earlier, since I'd said yes to TANF, the internal logic is going to make me put a DHS case number, and it also makes me populate the months received TANF in the last 60 months. So now we're going to speak about food stamps. Personally receives or is a member of a family that receives or received in the past 6 months the Supplemental Nutrition Assistance Program, SNAP assistance, under the Food and Nutrition Act of 2008. A significant change from WIA to WIOA for food stamps. This used to be under WIA, it was personally receives or is a member of a household that receives food stamps. And back in those times, it required the client, if he or she wasn't the primary in the food stamp, they had to show up on the food stamp printout household. So that's no longer applicable. They are not required to show up on the food stamp household if they're a member of the WIOA defined family. So in this case, now I've said yes to food stamps. So I've said yes to both food stamps and yes to TANF. So when it comes time to certify this application, my documentation would need to be shown both food stamps and both TANF. It doesn't make the client doubly qualified because they meet eligibility for low income 2 different ways. But if, again, I've said yes to 2 different ways, I would need documentation for both. Question about food stamps. Betty is currently receiving food stamps. Her son, Tommy, lives with her. If Tommy came in for WIOA services, could he be determined low income based on food stamps, even if he does not appear on his mother's food stamp account? And the answer is yes. Going back to that criteria, WIOA low-income criteria can be determined based on personally received or as a member of a family that received or received in the past 6 months the SNAP benefits. So since Tommy lives with his mother, who is receiving food stamps, he could be determined low income based on his mother, Betty, receiving food stamps. Now here's one of the things that sometimes questions come up. That definition of a family, it speaks about parent, guardian, dependent children. Well, if Tommy is aged out, let's say he's no longer considered a dependent for age-wise, and he aged off of his mom's food stamps, could we still bring him in even though he's aged off the food stamps? If a client is still living at home with moms and dads and mom and dad's on food stamps, it's fine for them to come in under mom and dad's food stamps. Now, if they're no longer living there, it's another story, but if they're still living there, guess what? They're still eating mom and dad's food. So even if they're not, and again, they aren't required to show up on the food stamp printouts because it is based on family. Next, we're going to transition into homeless. Homeless is an automatic low-income qualification factor. Now the WIOA definition gave us two different definitions. They gave us the Violence Against Women's Act of 1994, as well as the McKinney-Vento Homeless Assistance Act. The McKinney-Vento Homeless Assistance Act is what was under WIA. So they've expanded it to include the Violence Against Women's Act of 1994. If you haven't ever done this, I highly recommend you Google and get that definition of the Violence Against Women Act of 1994. It's a much broader definition than the McKinney-Vento. Again, if a client meets the criteria that's in these two definitions, you check yes to homeless, and then it is an automatic low-income qualification factor. Some of the things that comes up often is, hey, well, what's the documentation for it? Documentation could be as simple as a client's attestation of their homeless status. It could also be documentation from somebody providing temporary residence, documentation from a shelter. A lot of times people are reluctant to mark homeless for somebody. Here's a little bit of background. Each quarter, we're required to forward to Department of Labor information on all of the WIOA registrants and exiters. Routinely, we get feedback that Illinois does not serve enough homeless people. Routinely, it comes in. Well, a couple things. If a person's truly homeless, it is a difficult population to serve because they don't have that fixed residence or a fixed, a lot of times, phone number or something. But a lot of times, we're dealing with folks who might meet the definition of homeless. That's the reason why I encourage you to look up that Violence Against Women Act, because it's very broad, and it doesn't just have to be women. It's both women and men. It's anybody that's affected by that definition. So if you're going to work with a client who meets the definition, you're already putting him or her in for services. You're just not getting credit for the barrier that they're dealing with. And I'll give you an example. One of the definitions under the Violence Against Women Act is people that are living in motorhomes, like on campgrounds. I owned a motorhome when I moved back to Illinois, and I lived in a campground for 6 months. So by definition, I was homeless. I met the definition of homeless because I didn't have a permanent residence and I was living out of my motorhome. So that's just an example of a portion of that definition under the Violence Against Women's Act. So in the application, it's on the characteristics and barrier screen. And the question's simple, it's homeless. If it's populated with a yes, it's going to get picked up as the barrier of low income. The next thing we're going to talk about is free or reduced price lunch. One of the things to understand about free or reduced price lunch, it's only for in-school youth. So if it's for an adult population or an out-of-school youth, you cannot use it. The current situation, some schools are back in session, some aren't. So the documentation for it is from the school that shows how the client, by name themselves, is receiving free or reduced price lunch. So it's not anything that you can get other than the school providing that information. And here's some feedback that came in Teagle 2116 about the free or reduced price lunch. It was clarified in schools where the whole school automatically receives free or reduced price lunch. WIOA programs must base low-income status on an individual student's eligibility to receive free or reduced price lunch or on meeting one of the other low-income categories under WIOA. So what this means is if the school is under entire school or school district's free or reduced price lunch, you cannot use that as your documentation. You have to have something specifically that states the client does. So if I'm your youth that's in school, it would need to state specifically Jim Potts is receiving free or reduced price lunch. And here's kind of the rub on this. A lot of schools or school districts, they do the entire school or school districts because they don't want to signal out people. So sometimes schools or school districts are reluctant to give documentation that singles out an individual. So what we have to do is explain to the school that this is a criteria to help a client receive services. And if we don't have the documentation to support this, then they have to find other ways to support their eligibility. So what I've seen is the schools often might give a documentation, something along the lines that Jim Potts receives free or reduced price lunch just like all the other students within our school district. And then it's signed by the principal or whomever at the school gives that guidelines. But again, it must specifically state that the client's name, or else you have to find another way to make him or her low income. The question is on the youth barrier screen, eligible to receive free or reduced price lunch. If it's answered with a yes, the internal logic is going to pick that up as low income. Now do keep in mind, this is only for low income for an in-school youth. That's not a barrier to support eligibility. So the client, him or herself, still must have one or more of the youth identified barriers. The eligible for free or reduced price lunch just meets the low income portion. So a question about free or reduced price lunch. Sally is currently a junior in high school, and in the school district she attends, all students are eligible for free lunch. She has applied for WIOA services. What documentation would be needed to support her WIOA low-income criteria due to free or reduced lunch? The documentation would need to specifically address that Sally herself, by name, is eligible for free or reduced lunch. If the school will not provide that information about an individual, then the client must find another way to support WIOA low-income criteria. Next one we're going to touch on is foster child, a minor on behalf of whom state or local government payments are made to a foster parent or other guardian. The criteria is on the characteristics and barrier screen. If a foster child is populated with a yes, the internal logic is going to pick it up as low income. This could be used both for an in-school youth and out-of-school youth. And in some instances, it could even be used for an adult. If a client is turned 18 and he or she is still considered a foster child, they would make them low income. They'd make them eligible as a low income adult due to the foster child status. What I found is most times, and not always, that a lot of times when a child or an individual turns 18, they age out of foster care, but it's not always. Sometimes they'll stay on longer. So a question about foster child documentation. Conrad is currently a senior in high school. He lives with his foster parents. What is the documentation that could be used to support his WIOA low-income criteria due to foster child status? So on this, if you look at the different documentation choices within the attachment A to support foster child status, includes the following: a court contact, court documentation, medical cards showing foster child status, verifications of payments made on behalf of the child, written statement from a state or local agency. One of the caveats I do want to put on that medical card showing foster child status, it would need to specify on the card that he or she is a foster child. For years, we would say, well, this code means this or this code means that. Unless you have a cross-reference that shows a code references to foster child, you wouldn't be able to use that medical card showing foster child status. It has to be clear on that. What we find most often, it's usually at verifications and payments made or a written statement from the shelter, or excuse me, a state or local agency. Next thing I want to touch on is a youth living in a poverty area. According to WIOA, both in-school or out-of-school youth qualifies as low income if they live in a high poverty area. Many of the rural counties in the U.S. have a high poverty rate of 25% or above. Now, there was new guidance issued in April of 2020 on the steps to determine criteria. This next few slides will provide this additional guidance on this. It's a lot of small writing, so I've sent out this PowerPoint, and it's instructions you have to follow through. If anybody out there has followed through this process and they'd want to give me some additional feedback that I could include for future presentations, I'd highly appreciate that. So I'm not going to bother reading it. It's a lot of the similar steps that what it was before, but there are some differences now compared to what it was. You've kind of got to go through 2 or 3 steps where it used to be a little simpler, the way I've understood. And one of the things also to understand is, of course, the new census is going on right now. So once that gets done, some of these areas are going to be changing, I'm sure, based on circumstances. A lot of stuff that's going on right now with COVID, I'm sure it's going to be changing a lot of our areas around the the country for the high poverty areas. So again, this was an excellent way of making low incomes, because I think once you figure out your areas, you'll know the boundaries within your geographical area of the areas that do meet it and maybe those who don't. So it will help you once you've identified those that you can use this criteria. One of the things also to understand, it is only for youth. So if you have a in-school or out-of-school youth and whose low income was determined based on poverty area, if you are ever attempting to co-enroll that individual under the adult funding stream, and the only way they met low income was due to the poverty area or living in the poverty area, you would not be able to use that criteria for the co-enrollment for the adult application low income. They would need to find another way. The question is on the youth barrier screen. It's simple: a youth who lives in a poverty area as determined by the census tract. If you populate that with a yes, the expectation is you will have that documentation that you've went through and you have that in the hard copy file. So sometimes we've had cases where people just answered yes to this because they really didn't understand the question. You really have to understand what you're checking. You're stating that you've went through the steps that to find it, and you have that documentation in the file to support that the client is living in that high poverty area determined by the census tract. So if a youth client is determined low income based on living in a high poverty area, and then at a later date you would like to co-enroll the client into the adult services, could you certify under adult low income? And we just covered this, and the answer would be no. Only the youth clients are able to utilize that criteria of living in a high poverty area for determined WIOA low income. Something else I want to touch on this, also living in a high poverty area, it's not a barrier for youth criteria eligibility for WIOA. It could be used to determine low income, but the youth would still have to have one of the WIOA defined barriers. Now, for those of you at the local workforce area who have, who make policy for your local area, this could be an excellent criteria for the youth needing assistance. If a youth lives in a high poverty area, or if a youth is on free or reduced price lunch, it would make a perfect sense for that to be one of the youth requires additional assistance barriers criteria. So it might be something to consider. So now if we have a client and he or she, they did not meet any of the automatic qualifiers, meaning that they weren't on any form of cash welfare, they weren't on food stamps, they weren't foster child, they weren't homeless, they weren't receiving free or reduced price lunch, and they weren't living in a high poverty area. So the only way left now are dealing with income calculations. So to do an income calculation, first you're going to capture all the people in the WIOA defined family, and then we're going to determine what income those individuals have in the last 6 months from the application date. And then those are all added together based on family size and the total family income. It's important to exclude that income that's the excludable income. As the example I've used about people that are active duty military, all pay or allowances is excludable. So it's really important to go through the low income individual's policy and take out all that information that's excludable. And then the individual to be determined low income must be at the poverty line or 70% of the lower living standard income level, the LLSIL. So a lot of times people say, well, what is the poverty line compared to that? The poverty line is 70% of the LLSIL. So they go hand in hand. So some of the requirements, again, you must capture the income on each individual within the WIOA defined family, pay stubs or other acceptable documentation for each of the family members, documentation supporting family size. That term family, I'm going to show that another time. That term family means 2 or more persons related by blood, marriage, or decree of court who are living in a single residence and are included in one or more of the following: a married couple and dependent children, parent or guardian dependent children, or a married couple. Here's some guidance. It's really important. This came out in TEGL 2116. It's applicable for both the youth and the adults. And what the guidance states is if an individual is not living in a singles residence with other family members, that individual is not a member of a family for purposes of WIOA income calculations. So breaking this down, meaning if an individual is not living with their WIOA defined family, then their income determination should be based on their own income. This comes into play a lot of times if you get boyfriends and girlfriends living together. For years, that was a difficult one to know how to appropriately do an income calculation. So I'm really glad it was clarified with the TEGL 2116. So in this instance, if you have a boyfriend or girlfriend living together, or even, let's say, two siblings, the adult brother and sister, they live with each other. They don't meet that WIOA definition because they wouldn't fall under the guidelines of parent, guardian, dependent children, or husband and wife. So in that case, each individual is based on their own income. So again, this was a good change. I'm glad to see clarification on that. So now we have a question. A 19-year-old individual, Tom, is applying for WIOA program. He lives with his older sister, Tori, and their cousin, Sue, who is 23. Both Tori and Sue are also thinking about applying for WIOA. So how many people would be considered to be in the WIOA defined family, and whose income would be included to determine the low income status? So if these individuals came in, none of these individuals would meet the criteria under the WIOA family definition. In each case, it would be a family size of 1, and each individual's low income status would be based on their own income. So again, they don't meet the WIOA definition of family. Just because they're related by blood, it doesn't put it in that whole definition of parent, married couple, parent or guardian, or married couple with dependent children. So in this case, they're each individually on their own. So again, for a family income calculation, it is essential that you really understand that inclusions and exclusions list, especially that exclusions list. Any family member that counts towards the WIOA defined family must have the included income for the previous 6 months prior to the application date for the family income calculation. And then you have the income chart. And on this, you would record, it gets a little tricky if you're dealing with a family that has a large number of people in, because you're going to be adding all the different incomes together, and you'd have all the separate documentation together to support that. So after the entire family income has been loaded into the income calculation screen, the career planner must calculate the totals. So in this case, you put it in, you calculate the totals, and it gives you the total income guidelines. And that's when you'd go, there's the WIOA, or WIOA Notice 19.03, and it breaks it out by the family size and by the income level. So if this particular client is an LWIA 20, so when you look at the annual income of $37,620, I'm here looking at that WIOA Notice 1903, and on that, when I look across, for a family size of 6, they can have a maximum income of $38,257. So it would be below that for a family size of 6. If it's a family size of 5, the maximum family income would be $32,706. So the only way this family could be low income would be if it was a family size of 6 or greater. So on this, then the client must have family characteristics screen if an income calculation must be recorded on all the family members. In this case, you have the choices. You have a case of a parent in a parent family, and again, that definition of family comes into play. We have the applicant herself. We have her spouse. And this is a question: could a 19-year-old stepchild still be considered part of the WIOA family? And yes, he could. In other cases, though, if you notice, he has income. So depending on a level of income, you know, a lot of times you'll get adult children that are still living at home, and maybe they're no longer really part of that family for income. Maybe he's just living there for rent, and room and board, and his income's not going towards the family. But in this case, his income is going, so they're counting him as part of the WIOA defined family, so his income does count. And then we also had 3 other children. You had a 5-year-old, and you had twins, Julie and Julia. So the family size of 6. So as I mentioned earlier, for this particular case, the income would have been a maximum for LWIA 20 of $38,257, and they were well under that for a family size. So we know they would meet low income guidelines in this example. Now for the income calculation, the career partner would be responsible for having the income verification document for each of the individual in the family that had that income. If the family is over income and the client does not meet any of the automatic low income qualification factors, there's one last way a client could meet low income criteria, and that's called a family of one due to a disability. And how a family of one due to disability works is if you have a client who has a disability, him or herself, and their own income is below the poverty line or 70% of the lower living standard income level for that family size of one. So right now, that family income size of one is $12,760. So basically you're looking at somebody if they have more than what, $1,070 or less than $1,070 a month, they would meet low incomes due to a family of one due to a disability. Now, IWDS must be documented 3 different places to accurately record family of one due to disability. On the private information screen, a disability must be identified. Then on the income calculation screen is where the client's own income would be documented. And then that family characteristics screen where the criteria of a family of one is specified. So to demonstrate, this client would have to have a disability. So any response other than no or preferred not to answer would get picked up as a disability. The client's income for the previous 6 months. So in this case, the client did have income. She had $1,007 a month for 6 months. So that's $12,084, which is under that threshold of family size of one, which is $12,760. And then on the family of characteristics screen, since the disability was recorded, it gives you the option to do family of one due to a disability. So in this case, we populated it as a yes. You would not need to list the family member. Sometimes people try to list the family member, and if the client's under age 18, it causes problems. So when a family of one due to disability is used, it would be known that the client is that family of one. So you would not list him or her under the list family. So on this, 17-year-old Holly is applying for in-school youth program. She lives with her parents and their family income is above WIOA, the low income criteria guidelines. However, one of Holly's barriers is a disability due to a hearing impairment. Her own income is less than the family of one income criteria, so she will meet low income criteria of the family of one due to disability. Would a self-attestation be acceptable documentation to support her disability is the question. And the answer to that would be no. A self-attestation for the disability would not be an acceptable documentation choice under these circumstances due to the client is utilizing family of one due to a disability to support her low income criteria. So she would have to have that formal documentation to support her disability. So here's just some clarification on that. In cases where a youth client has multiple barriers, in instances where youth has multiple barriers that supports eligibility and low income determination of the family is not based on a family of one due to disability, the formal documentation for the disability is not required and the self-attestation could be used. The thought is it's to be less intrusive in regards to the individual's documentation of the disability, since the client would have other barriers to support their eligibility beyond just that disability. So back to this example, family of one due to disability. We have documentation addressing the income and documentation addressing that disability. And here it shows on the eligibility certification, you have income, the county, and then the family size. So if somebody is a family of one due to disability, the appropriate response would be disabled, and your documentation would be that documentation to show the disability. So the 8 ways an individual could be determined low income in WIOA, 6 different ways do not require capturing low income or doing a low income calculation. And those could be cash welfare, food stamps, homeless, free or reduced price lunch, foster child, or youth customer living in a high poverty area. If a client does not meet one of the previous 6 automatic qualification factors, that is when the income calculation should be utilized to determine low income status. All determinations of low income status for customers must be supported by that proper documentation of the qualifying condition as outlined under WIOA Title 1B, General and Fund Source Eligibility Requirements and Documentation Sources. And that concludes the presentation on low income. So we got a few minutes to answer any questions that might be in the chat box. Is there anything in there, David?
There are a few questions. Janet, I think you might have to unmute yourself.
Yes.
Excellent. I'm here. Can you hear me?
Yep,
Yes.
we hear you.
Okay, there's a couple questions here.
Okay, shoot.
Alrighty. It says, if a person born female and got a sex change and now has birth certificate that says they are male, what do we do?
Well, if a person states now that they're a male, then they have requirement to be compliant with selective service.
Okay, question 2. Is there an IWDS report to show in-school youth low income percentage to ensure we are meeting the 95% low income requirement?
No, there's not a report in there, but it's more of a reverse of that, because each local area would be monitoring their own 5%. So they would be tracking their 5%. So it's more of a reverse on that of what would be tracking. I know if this is coming from a person at the local area that would need to have some benefits, I know Steve Placek in LWIA 5 has a good way of tracking that. So maybe I could get with him and find the tool that he uses to track that. But there's not a report that I'm aware of that specifies all the clients who are low income. Again, it'd be a reverse because you're looking for the 5% who aren't. So, but there is no report that I'm aware of. Next question.
If a person lives in a high poverty area, do we still need to calculate income? The person in question's income could, what's that?
Nope, that's a great question. No, if a person meets any of those automatic low income, so if it's a youth and you have documentation to show that they're living in the high poverty area, then they meet low income. You do not need to do an income calculation. They can be over income and they're still good to go as long as you have that documentation. That's the beauty of that living in a high poverty area. It's an automatic qualifier.
Okay,
But
that
it's a really good
answers the
question.
second part of the question. Okay, does an 18-year-old who lives with a grandmother who receives the link card qualifies as low income if the youth is not listed on the link card?
Well, on that you're looking at, is the grandmother considered the guardian or parent in the situation? So in some instances it is, some instances you look at the grandparent has been giving the authority to serve as the guardian for the youth. So if the instances where the grandparent is considered the guardian of the individual, then yes, they wouldn't have to be on the report, then they could show up. But if it was just that he got tired of living with his parents and he's 19 and he moved over with his grandma and she's not serving as the guardian, and it shouldn't work that way. So again, it's kind of depending on the circumstances of how the setup is with the dynamics. Is the grandparent serving as the pseudo guardian? Next question.
Okay. Can you provide the Teagle notice that provide updated high poverty directions because they're not seeing it?
Yep, that's a good
So
one. It came out from policy. It's been sent out a couple times, but I'll make sure to get with Laura Dahm with policy, and I'll make sure that for everybody that's in this too, that we get that guidance sent out from our policy unit. So.
And that's all.
Next question.
No, that's all the questions.
Excellent. Well, it's 10:30, so it works out perfect for timing. I thank everybody for their participation today. The next one on WIOA adults and youth will be on Monday, the 14th at 9 a.m. and will also be scheduled to go till 10:30. If you have any coworkers who is going to participate in the Monday 14th session and they didn't participate today, they would need to review this recording because, again, it's going to cover low income and the general eligibility. We will not be going over those in detail again. We just won't have the time on Monday. So sounds good, and I look forward to talking to everybody on Monday, and have yourself a great weekend. Thank you.